Now, during the initial interview, the attorney will provide an initial consultation. This initial consultation will likely include legal analysis of some sort, where the attorney is going to ask questions, listen to the facts, determine what area of law the issue is, and then provide some brief legal analysis on the matter. That might also include what to expect and possible remedies. There may be several different avenues that can be taken depending on the type of attorney and depending on what that attorney thinks is the likelihood of success for different avenues. So the attorney may say something to the effect, well, this situation sounds like a good one for settlement, because unfortunately if we were to go to litigation, this probably wouldn't lend itself to a win, but we need to do further research to make sure of that, and I'll let you know in the next few days. It's unlikely. The only type of final legal analysis that might come up in this situation is if the attorney definitely thinks there's not a case here. If that's the case, then the attorney may actually say, you know, there's not much that can be done, particularly if there are documents there that can be quickly reviewed. I remember one instance where I had a client who used a property management company to lease out his condo. They were supposed to provide good tenants for the land, or for the lease. Unfortunately, the agreement he signed, the prospective client's agreement, was included an indemnification clause, pretty much waiving any possible remedies he might have against this company for bringing in shoddy tenants. The tenants had destroyed his property, but the contract was very clear in that case. So unfortunately, during that instance, I had to let him know right from the beginning that it's not very likely that he would succeed in any sort of case. So that's an instance where you might actually see the attorney providing semi-conclusive analysis. In most cases, the attorney will always offer to proceed forward if there is a chance, but because of the risk involved, it will usually cost more, and the client will have to weigh whether it's worth his time, particularly depending on how much damage is caused or what sort of remedies he seeks. So, what happens after the initial interview? Well, after the initial interview, particularly if the paralegal is involved and is going to continue to be involved in the case, then there's likely going to be a conversation between the attorney and the paralegal. So what did you think? How did you think, how truthful did you think they sounded? What did you think about those facts? What did you gather from them? Some attorneys are very standoffish when it comes to other people's opinions, so it just depends on what kind of attorney you're working for. The paralegal may be asked to draft an initial intake memorandum. This would summarize the facts, what was heard, basically summarize the notes, that were taken during the meeting, what the next steps are. If the attorney assigned a task, that would be included in there. Basically something that would be placed in the file to notify whoever's looking at the file where the case has been and where it's going. If the attorney is willing to accept the client as a client, then you might be required to draft the retainer agreement. Which we'll go over in a few minutes. The retainer agreement provides that for a retainer, and a retainer is an amount of money that is put aside in the firm's trust account from which the firm can take money once it's earned. It's still the client's money, but it's retained for services rendered to be paid to the law firm. If there are instances where there may not be a retainer, in which case it may be a fee agreement that you'll be asked to draft, and that may be in cases of a flat fee, an hourly fee without a retainer, or a contingent fee. The flat fee is a fee that, like a divorce, let's say, or drafting a will. If it's something simple, then it may be $500 flat fee for a will to be drafted, or an hourly fee without a retainer agreement. If it's a simple matter that's probably only going to cost $100, $200, $300, a couple of hours of the attorney's time, then a retainer may be unnecessary. Usually, though, retainers are very necessary. They ensure that the attorney isn't wasting his or her time, that the law firm is actually going to get paid. Lastly, contingent fees usually don't have retainers with them. Contingent fees, you hear that attorneys take 33 1/3%. It's in a contingent fee situation that happens. Whatever you earn, whatever you get from the lawsuit, the attorney will get a certain percentage of that amount. Okay. I want you to take a look at Exhibit 8.1 in the book. It's an example attorney-client agreement. It's very likely that as a paralegal you will do these agreements, or you will draft these agreements on multiple occasions. Because of that, your assignment is going to be I want you to type out the entire agreement and fill it in. You can make up names and you could fill it in with whatever information you want to fill it in with. But I want you to pay particular attention to what you are writing. It's very important that you understand it, because when you write these agreements, usually the law firm will have a form. So that'll be an example form. But you need to be diligent and ensure that the information that's being placed in the blanks, that information is relevant to the context. Making sure he refers to a man and it refers to a company. The simple things as well as the more complex things. You won't be putting information about contingent fee in a retainer type of an agreement. This assignment will be worth 25 points. The first part of the assignment is to do the copying. The second part of the assignment, which will be a separate document, is I want you to summarize each part of each section of the document. So instead of actually writing it out, I want you to summarize in your own words what you think that particular section does. And that too is worth 25 points. So this entire assignment is worth 50 points. It's very important. It's something you'll likely do a lot as a paralegal. And it introduces you into that world. So pay particular attention to this. Know that there are multiple ways that a fee agreement can be done, but you need to get used to what it generally looks like. All right. What goes along with the fee agreement, and sometimes as part of the fee agreement, the engagement letter. This is the letter that tells the client that the firm is willing to engage the client in this matter. It can be in the form of a cover letter, and it will deal with the scope of the representation. If it's family law, for instance, the engagement letter would mention that the scope of the representation is with, in regards to the family law issue mentioned above in the subject line or what have you. If it's for general representation, then it would say all legal services, regardless of the matter. The scope is important because this provides the client, this allows the client to know exactly what sort of legal fees he can be looking at. Is it just going to be legal fees dealing with family law and related matters? Is it going to be any legal issue that he presents in front of him? How is the firm engaging the client? Like I said, it could be in a cover letter, or it may be the very letter that is the agreement, the attorney-client agreement that includes the fees and the like. The alternative is the non-engagement letter. This letter specifically states that the firm will not be representing the client. And that could be because of a conflict, because the firm doesn't think that there's a case, doesn't want to handle the matter. A law firm doesn't need an excuse not to hire a client. It's up to the firm to do so or not to do so.